Can a joint bank account be frozen? Have you ever wondered what happens to a joint bank account when one account holder faces financial trouble? This is an important question, especially in the context of estate planning and the probate process. So, can a joint bank account be frozen? The answer is yes, and there are specific reasons why this can happen. When a creditor obtains a court judgment against one of the account holders, they can initiate a process called garnishment. This means the bank may freeze the entire joint account. Once the bank receives a restraining notice or garnishment order from the court, all transactions are halted. This includes withdrawals and deposits, leaving both account holders unable to access their funds until the issue is resolved. One key point to remember is that the bank does not differentiate between the contributions of each co-owner. This means that even if one account holder contributed all the funds, the entire balance can be frozen. This can create significant challenges for the non-debtor co-owner, who may need access to those funds for daily expenses. Typically, account holders are not notified before the freeze occurs. They only find out when they attempt to make a transaction and discover their account is frozen. This can lead to unexpected financial stress, particularly if the non-debtor co-owner relies on those funds. Certain funds are protected from garnishment. For example, Social Security benefits, disability payments, and pensions are exempt. If these funds are deposited into the joint account, the non-debtor co-owner may be able to access a portion equivalent to at least 2 months of federal benefit payments. However, proving which funds are exempt can require legal action, often involving a court hearing. If one of the joint account holders passes away, the bank may temporarily freeze the account. The surviving owner will need to provide court orders or go through probate proceedings to access the funds. This can lead to delays and additional stress, especially for those managing estates or caring for elderly individuals. Because joint accounts can be frozen, relying solely on them to avoid probate can be risky. Estate planning strategies often include trusts or other legal tools to ensure smoother access to funds and better protection of assets. If a joint account is frozen without sufficient cause, the affected party can challenge the freeze. This usually involves submitting documentation to the bank or even filing a lawsuit. Legal assistance can be crucial in navigating this process effectively. In summary, while joint bank accounts can be convenient and help avoid probate, they are not immune to freezing. Understanding the implications of joint ownership is essential for effective estate planning.